Okay, welcome to our post-argument discussion of this case McGirt versus Oklahoma. I'm here with my friend Bob Anderson. My name is Sarah Harrington. I'm a partner at Goldstein and Russell. I'm a primarily Supreme Court litigator. Bob is a professor of law at the University of Washington School of Law and a visiting professor at Harvard Law School. He is sort of the subject matter expertise person here. He knows all about Indian law, and my value added is more talking about the Supreme Court and practice of the Supreme Court. So in case you all were not able to join us for our preview of this case last week, or in case you missed the argument yesterday at the Supreme Court, I'm just going to start by giving you a little bit of a recap about what this case is about. So this is a case called McGirt versus Oklahoma. It's about the criminal conviction of Mr. McGirt. He is a member of an Indian tribe. He lives in Oklahoma, and he was convicted of a serious crime by the state of Oklahoma. He is arguing that the state did not have jurisdiction to prosecute him for that crime because he committed it in a part of Oklahoma that is actually an Indian reservation, the reservation of the Creek Nation or Muskogee Nation. He says that basically the eastern half of Oklahoma is an Indian reservation or a combination of Indian reservations, and that because there's a federal statute called the Major Crimes Act that gives exclusive jurisdiction to the federal government over serious crimes committed by Indians on Indian land, that the state did not have jurisdiction to prosecute him for his crime. And just to give a little bit of take a step back and give a little sort of backdrop on how this case got to be where it is, there was a case called Murphy versus Carpenter, Mark Carpenter versus Murphy last year that the court accepted and heard argument in that presented the same question. And the court heard argument and then asked for supplemental briefing, and then we waited and waited and waited, and nothing ever happened until the very end of the term, so June of last year, when the court said, we're going to kick this case over to the next term and hear a re-argument in the case. Now, in that case, the Carpenter case, Justice Gorsuch was recused. So normally you have 9 justices. There were only 8 justices. And so everyone basically assumes that there was a 4-4 tie among the 8 justices, that they could not reach a decision. So that they decided to kick it over. And then what they did is they waited for another case to come along in which Justice Gorsuch would not be recused, and that is the McGirt case. So the major question is whether the Indian reservation of the Creek Nation, an Indian tribe, was ever disestablished, is the phrase that they use in the federal law. So it existed, and then Congress has the authority to make it unexist, to disestablish it. And the question is whether the Creek Nation's reservation was disestablished. Now, the court heard argument in this case yesterday morning. Because of the situation we're all in, we're coming to you from our homes here. The court was not able to hear a live argument. And so in sort of a historic turn of events, last week and this week, the court has been hearing telephonic arguments. And I'll talk a little bit more about the mechanics of that when we get into talking about the argument yesterday. But I'm going to let Bob sort of give us a little more details on the legal issues in the case. There's a couple of cases called Parker and Solem that kind of govern the framework of determining whether a reservation has been disestablished. And I just want to say, as we go along, there's a Q&A feature near the bottom of your screen for those of you who are with us live. You're welcome to submit questions and we will do our best to answer them. Some people mistakenly submit them through the chat function. We'll keep track of those too, but if you can, there's the Q&A function right next to the chat function if you could submit questions there. So I wanted to sort of start off by asking Bob if he can sort of explain to us a lot of the legal issues in the case, discuss kind of the different legal statuses of land that was held by an Indian tribe or by members. And so maybe Bob could give us a little bit of a primer on that.
Okay, great. Thanks a lot, Sarah. Well, the overarching term in the Indian law field is Indian country. And that was a phrase that was used by Congress in one of the first laws that passed in 1790 that delineated areas that were exclusive federal areas and tribal areas of jurisdiction. So the states didn't have any authority within this area called Indian country. And it wasn't defined by Congress until 1832. And in that definition, they just said, well, it's places where Indian tribes have not surrendered their original rights of use and occupancy. Sometimes it's called aboriginal title. And that definition stayed on the books until the 1880s, but it kind of became obsolete because of the way that the United States developed with all the westward expansion, and the court never really relied on it again. And so starting in the late 19th century, the court started to look at, well, what is Indian country in terms of where these major crimes would fall under federal jurisdiction, or where statutes like the federal Indian liquor laws would apply, or where would tribes have the power to exercise their authority to the exclusion of the states. And the court, in a series of cases, said, well, Indian reservations, which were established by treaty with the United States, sometimes by statutes that confirmed agreements between the United States and tribes, or by presidential executive orders, were all considered Indian country because they were reservations. And the court didn't use any magic formulation to determine what was a reservation. Sometimes the documents used that phrase, sometimes the land was just set aside for tribal use and occupancy. The creeks were unusual in that they were in the southeast United States and were removed by the United States in the 1830s to present-day Oklahoma. So they were outside of their Aboriginal territory, but Congress in the Treaty of 1833 delineated boundaries in eastern Oklahoma for the Creek Reservation, and they used the term reservation in a couple of the treaties that came along after that. Significant to this case, the United States granted the Creeks what was called a fee patent. They gave full ownership of the land to the Creek Nation, and Oklahoma makes a big argument about that, saying that it's not a reservation. And that's an argument that they didn't make last year, but they made in this argument the other day. The United States, which is on the same side as Oklahoma, doesn't agree with that. The United States says it was a reservation, which would be Indian country. Within the Indian country statute that Congress finally set out definitions for in 1948, they set out three different categories. Reservations, including all lands within the reservation. And that's important because that's the argument that Oklahoma thinks is going to cause so much prospective harm, because eastern Oklahoma, where the Cherokee Reservation is located, is predominantly owned by non-Indians or state governments. The tribe has some land, but not a great deal. And individual tribal citizens have what are called allotments, which were created around the turn of the century, the 19th century to the 20th century, to break up the communal land ownership pattern that prevailed on the reservation. And so you have these, get a lot of talk about allotments. And then there's this other category called dependent Indian communities, which are areas that have been treated as Indian country under a number of court decisions. An important one out of New Mexico called the Sandoval case, where the Pueblos held land in fee simple, and the court said that that is Indian country. And they said that Congress had the power to do that because the Pueblos were dependent peoples, dependent on the United States for their protection and advancement. And so there's Indian country consists of reservations, dependent Indian communities, and allotments. And so what we're talking about here is whether this is a reservation, and that's the tribe's theory, that it was a reservation all through the treaty period, and that it has never lost that status. The state says, well, the reservation was diminished, and its fee patent means that it was a dependent Indian community, so only land owned by the tribe or subject to some sort of a federal protective statute is subject to federal criminal jurisdiction. And Mr. McGirt committed his offense on non-Indian fee simple land. And they say that means that he can be prosecuted by the state. And so it's a complicated set of theories, but it's interesting to me that the United States and the Muskogee Creek Nation both agree that this was a reservation at one point. And the United States says, What happened is that all the criminal jurisdiction got transferred by Congress in a series of overwhelming statutes that led up to statehood. When the Creek government was headed down the road to abolishment, when the Creek courts were abolished, and they make a very persuasive arguments, and so did a bunch of the amici in support of Oklahoma. The Creek nation and Mr. McGirt, on the other hand, come back and say, look, the US Supreme Court has set out a very specific test regarding whether or not a reservation's boundaries have been terminated. And Sarah mentioned Solem versus Bartlett, a 1984 case, and Parker versus Nebraska. And both those cases start out with the premise that Congress has the authority to abolish or disestablish a reservation if it chooses to do so. But that it has to be clear and express in the text of the statute that they intended to make such an abrogation or disestablishment of reservation boundaries. Some of the cases that have come up in between Parker and Solem looked at modern demographics, like who's living there now, and what happened immediately after statehood, and all seem to agree that after statehood, or after the disestablishment in this case, that the federal government stopped exercising criminal jurisdiction, and Oklahoma started exercising jurisdiction. The Creek Nation says, well, that's not uncommon that the United States abdicated its responsibility to enforce federal laws to protect Indian communities and Indian citizens, and the fact that the state illegally asserted jurisdiction for the last 100 years can't change the fact that Congress did not disestablish the reservation, because only Congress can do it, and inaction in illegal conduct by a state or by the federal executive branch can't lead to disestablishment. And Parker versus Nebraska, written by Justice Thomas in 2016, is very much in play here, because Justice Thomas said, well, you really have to look at the text. You got to find that the text has established the reservation. You can't look at these events, these historical events. You can't look at who's living there now. So he was, in his questioning, I think, trying to distinguish his own decision in Parker in order to find a way to uphold the state of Oklahoma's jurisdiction, is my assessment. So that's the background. I'll punt it back to you, Sarah.
Yeah, that's great. That's really helpful. Thank you, Bob. So there's sort of, as suggested by some of Bob's comments there's sort of two lines of arguments, or at least two, and two lines of concerns kind of at play here. The first is this sort of textual argument that the court has been clear that it's up to Congress to establish and disestablish reservations, and the way we tell if they've disestablished a reservation is by looking at the text of statutes. And I don't think anyone thinks that there's a really clear statutory text here disestablishing this reservation. And as I mentioned, Justice Gorsuch, who was recused in the previous case where we think it tied 4-4, he's in the case now, and so people naturally view him as a potential swing vote. And he, maybe more than anyone else on the court, is an avowed textualist and has said things like, I don't care what the consequences are, my job is to read the text. We have to follow the law, and it's not up to us to decide whether the law makes any sense. And so, not surprisingly, the first lawyer who was up, there were 4 lawyers who argued yesterday, Ian Gershengorn for Mr. McGirt, Riaz Kanji for the Creek Nation, Mithun Masingani, who's the Solicitor General for Oklahoma, and then Ed Needler, who's a Deputy Solicitor General for the United States. The Creek Nation and the United States were appearing as amici curiae, which means friend of the court, so they're not parties, but they have a significant stake in the outcome. And Ian Gershengorn, who stood up first, he started right away with the text. This is about Congress, it's about the text of the statute, there's no clear text. Obviously, clearly speaking to Justice Gorsuch. And so I don't know, Bob, if you had any thoughts about the textual arguments. It didn't seem like anyone was pushing like a really plain reading. There were some arguments from Oklahoma and the Solicitor General's lawyer about, they use this phrase called the original public meeting, which is kind of a version of a textual argument, which says basically, we don't look at the words and trying to figure out what they mean today. We look at them and what they would have meant back then. So they were making these arguments that if you looked at the relevant statutory text from the different statutes around the time that Oklahoma became a state, that it was clear that Congress thought, that everyone thought what they were doing was disestablishing the reservation. Bob, I don't know if you have thoughts about the validity of that argument.
Right, no, I thought that, I think that's that's a great argument to make when you don't have the text on your side. And I think
Right.
the problem is that Justice Thomas has said that it's the text that matters, and Justice Gorsuch, as you noted, is really saying, let's just read the text. And maybe everybody did understand that the tribe was going to go away. They were slated to have their government terminated in 1906, but that never happened. And their government was extended by a statute. And so, that may be what they thought they did, but they didn't do it in terms of that it being disestablishing the reservation. And so I think that's a tough argument. But as we were talking earlier, before the program began, some of the justices seem to be thinking, well, maybe we can find a middle ground here, that the reservation continues to exist, but that criminal jurisdiction was transferred wholesale from the federal government to the state of Oklahoma upon statehood. And Riaz Kanji and Ian Gershengorn, came back pretty hard on that, again, with textual arguments that indicated that, well, Congress can transfer criminal jurisdiction to a state, which they've done in many statutes, but the statutes passed here don't look anything like the ones where Congress transferred criminal jurisdiction to a state. So it's a tough argument, but the court seemed interested in this transfer of criminal jurisdiction argument.
Yeah, Justice Breyer, I think as we were talking about, he was kind of the main cheerleader for that argument. So the way they do these phone arguments, normally when there's an argument at the Supreme Court, there's a lawyer at the podium and he or she is speaking, and then the justices interrupt with questions as they see fit. Because they're all on the phone, that would not be workable. They take turns asking questions, and they go in descending order of seniority, where the Chief Justice starts, and then you have Justice Thomas, Justice Ginsburg, et cetera, down the line. And so each of the times we got to Justice Breyer, and so they each had a turn to ask a question of each of the four lawyers, because the argument is supposed to only be 60 minutes. I think it was like 92 or 93 minutes. It went long. And because there were two lawyers on each side, the justices only had either 2 minutes or 1 minute, depending on who the lawyer was, to ask questions. So it was a little bit of it was a strange flow, but each time Justice Breyer got his turn, I think every time or almost every time, he basically said, isn't there a way we can read some federal statute, not so that the Major Crimes Act, which is what gives federal courts exclusive jurisdiction over these types of crimes, doesn't apply here, that Congress intended the state to prosecute these crimes. And I do think, like, as you said, that's sort of a quest for a narrow ruling. And so basically that if they ruled that way, they would say, it doesn't matter whether it's still a reservation or isn't a reservation, the state had jurisdiction over this prosecution, and that's all we need to hold. And so it would just kick the can down the road, because there would be other situations in which the issue would get teed up again. But they sometimes do that if an issue is really hard, and I think this is a hard issue. They sometimes will just kick the can down the road. And so Justice Breyer, like I said, was very focused on that. Justice Alito kind of came around at the end and was asking follow-up questions about that. Sometimes over the course of an oral argument, you can see the justices sort of trying to scope out each other and where they are, and trying to like form up teams. You need 5 votes for a particular result. And so sometimes they'll try to probe questions that, probe issues that they think will convince one of their colleagues to join them. And so then there's sort of another line of questions and concerns that focus on the practical effects. And I see we have a question from one of the audience members about what will be the effects of a ruling one way or the other on other Indian tribes in the country. And so I'll swing back to that in a second. But there are lots of questions about what will be the practical effects. And so I think that's a signal. And there were even more, I would say, in the Carpenter case last term. But that's a signal that at least enough justices think, well, it sure looks like under our law, the reservation was not disestablished, even though everyone has treated it as such all these years. What's that going to mean? And so, Bob, I don't know, were you surprised by any of the focus of those questions? Or?
Well, it was not really. I mean, it was interesting to listen to Justice Breyer searching so hard for this, and it made me. I just remembered that he did a similar thing and voted with the conservative majority in Adoptive Couple versus Baby Girl, the famous Indian Child Welfare Act case, and he supplied the 5th vote. and through a concurring opinion that said, oh, this is a very narrow decision we're making here. It's not going to apply to many cases, and the non-Indian adoptive parents in that case won. And it seemed to me that he was steering himself toward that path in this case. And I saw a question about the national implications for this case. And I think that's what Justice Breyer and Justice Alito, I believe, at the very end were saying, well, if we say that this jurisdiction was transferred to the state, that's only because of these Oklahoma-specific statutes, in fact, the Creek-specific statutes. And so that would be a pathway to ensure that this doesn't have national implications, at least immediately, although it does supply another, quiver in the arrow of folks who are trying to avoid tribal, or arrow in the quiver of those who are trying to avoid tribal jurisdiction. And so it's very tight, I think, in terms of the lineup of the court here.
Yeah, and there was a question, I think it was from Justice Thomas to Ed Needler about what about implications for other tribes. And as you mentioned earlier, Justice Thomas, who wrote the decision in Parker, was searching for a way to say, well, Oklahoma is different. The rule we set out in Solem and Parker doesn't apply here for various reasons. And he or someone else asked Ed Needler, well, what's that going to mean for other tribes? Are we suddenly going to unsettle expectations of tribes in other parts of the country? And Ed's response was like, well, no, you could have a rule here that's just about the unique history of Oklahoma. But a lot of the sort of practical focus of the discussion during the argument was about what's it going to mean for all these hundreds of state prosecutions for crimes that now Mr. McGirt and the tribe say should have been prosecuted by the federal government and not the state government. And I thought one thing that was interesting was there were a lot of questions that were posed, inviting responses that would push back on the hysteria about that. And so Justice Gorsuch, for example, he basically, I'm going to paraphrase here, he basically asked questions saying like, can you tell me why the sky isn't really falling? And then other questions like, even if the sky were falling, don't we just have to read the text to mean what it says? And so Justice Ginsburg was asking Ian Gershengorn questions like, because the state has said, look, there's going to be all these people who are just going to be these murderers and rapists who are just going to be released on the streets. It's going to be mayhem. It's a terrible situation if we lose. And so Justice Ginsburg was soliciting answers along the lines of, well, there are limits on who can seek relief from state convictions. Many of them, the only relief they would get would then be to be re-prosecuted by the federal government, which often applies much stricter penalties. And so people aren't going to want to do that. There was one interesting sort of exchange over the course of the argument where Ian Gershengorn said, look, the state has access to the numbers to tell us how many of these people there are, and they just haven't ever given us numbers. It's been briefed twice. There was all these different briefs. We had an argument. They've never told us how many people could be affected like this, and I think we have to assume it's not all that many. And then the Solicitor General for Oklahoma got up and he gave some numbers for the first time. And when Ian got back up, he did not enjoy that. He said, these are just back of the envelope numbers that they're throwing out there. We don't have any basis to think that they're, we don't know what they're based on and stuff like that. So I thought that was kind of an interesting exchange. And generally, you don't want to be giving factual information for the very first time at the podium, even the virtual podium, because it can't be sort of tested by adverse presentation. So Bob, I don't know, did you have any thoughts about the number offering?
Yeah, no, I thought that was interesting because I thought that the 178 number of habeas petitions that had been filed since Carpenter versus Murphy was decided, or Murphy versus Royal at that time back in the 10th Circuit several years ago, and Ian in the tribe said, well, that's not very many cases. It's not the floodgates have not opened, and so that was interesting. And I thought Riaz Kanji really emphasized the brief from the members of Congress and former governors of Oklahoma about how they have all of these cooperative agreements with the states and counties, state and the county, based on the premise that there is a reservation there, and that this changing the status quo to de-recognize officially the reservation would cast those agreements into doubt. I have to say that I enjoyed the format of them going through each justice with just a little bit of time, because as you know, when you listen to a normal argument, the transcript is often a mess because they're interrupting each other and they're cutting the lawyer off, and that didn't seem to happen. Did you agree with that?
Yeah, I agree. I mean, it's nice for the lawyers, I think. I've only done it in the live format, and one thing that can be frustrating is you don't get to finish your answer to a particular justice because you can get interrupted and taken down another path by a different justice. And so here, although there was limited time, they were able to sort of stay on topic. There were a couple glitches yesterday, which I hadn't really seen before. The Justice Alito at some point, I don't know if he dropped off the call or he couldn't unmute or something, but they had to skip him and come back to him because the Chief Justice was like, Justice Alito. It was sort of like Bueller. You're probably all too young to get that reference, but he didn't tune in. And so then eventually he rejoined and they came back to him. And then Justice Kavanaugh was kind of interesting. Some justices ask very long questions. There's like Justice Breyer is the most famous for this. And when you're having live argument, it doesn't matter. But when you only have a minute and your question lasts, 68 seconds, then you've used up your whole time. And so twice Justice Kavanaugh basically used up his whole time asking the question, and then the advocate didn't get a whole lot of time to respond. So I thought that was kind of interesting. But speaking of Justice Kavanaugh, he asked a lot of questions when, he's sort of thinking about, he is like Justice Gorsuch is very conservative, but they have very different or somewhat different takes on things. Justice Gorsuch, like I mentioned, is very strict textualist. Justice Kavanaugh is kind of known for being a pragmatist. And so he's really kind of, he very often asks questions about what are going to be the real world implications of a particular ruling. And so he asked a lot of questions about what's it going to mean for non-Indians who live in eastern Oklahoma when they suddenly find out that they live on a reservation. And some of the answers that came back were like, not much. So I don't know, Bob, can you explain briefly the concept of concurrent jurisdiction? If you're a non-Indian living in an area that could be a reservation, what would that mean?
Sure. I mean, the Supreme Court has cut back severely on tribal civil jurisdiction over non-tribal members. So the Creek Nation would have very little additional civil regulatory or taxing authority over other Indians who are members of other tribes or non-Indian citizens within the reservation boundaries. And the biggest change would be in the context of the criminal situation. And so a non-Indian who committed a crime against any Indian, Creek, Cherokee, whoever, would be subject to federal jurisdiction under the Indian Country Crimes Act. And presumably there are some of those crimes, or quite a few of those, occur. And vice versa, an Indian who committed a non-major crime against a non-Indian would also be subject to federal court jurisdiction. And that's where Ed Needler in the US are at it, because the US attorneys do not want to be having to gear up to handle all of these cases in federal criminal cases in federal court. And so I thought, there was a little bit of discussion about the Marathon Oil case and whether the court could decide the case and put the decision on hold for a couple of years to give Congress a chance to fix the situation, at least prospectively, in the criminal context. So what do you think of that?
Yeah, I thought I got less traction yesterday than it had in the Carpenter argument, but I do think, I would be surprised if we get a decision that just says, oh yeah, it's a reservation, go. I think they're gonna try to either find a narrow ground or get some coalition together that says it isn't a reservation or it never was a reservation, although that argument didn't get a ton of traction. And if they can't get that coalition, I think I wouldn't be surprised if they said, well, we think it still is a reservation, but we're gonna, because no one has acted that way for so long, we're gonna kind of put that on pause and give Congress a chance to do nothing if it thinks that's fine, or to disestablish the reservation if it doesn't think that's fine. Now I'm gonna just pause for 1 second because we're gonna maybe give predictions at the end, but we are kind of interested in what you all think is going to happen. And so we're gonna put a poll up. And I think we're just going to do one poll, and the poll is going to be, who do you think is going to win? Do you think Oklahoma is going to win, or do you think Mr. McGirt is going to win? Are they going to find that the conviction's invalid because it's still a reservation, or for some other reason, or are they going to uphold it? So we're not allowed to vote, and so I don't know how you can do it, but you can look at your screen.
The screen
all right, so
popped up on my screen, yeah.
And so we'll give you a couple minutes, and I'll just say a few words about some of the advocates in the argument to fill the time here while you guys are voting. So one thing that's interesting, this is just sort of a tangential note, but there's a lot of discussion when you're in the Supreme Court world about the lack of diversity in the Supreme Court bar. It is very largely male Supreme Court lawyers and very largely white Caucasian people. And so yesterday there were 4 lawyers, they were all men, but 2 of them were people of color. And you really, there's more discussion generally about how few women there are, but there are even fewer people of color who argue at the court. So that was a nice moment for the court to, even though justices couldn't see them because they were on the phone, it was a great opportunity to sort of expand the pool of people who can argue in front of the Supreme Court. So I'll give you maybe another minute to vote, and then we'll see what the tally is and give some thoughts of our own. One other interesting aspect of the argument was, as I mentioned, Ed Needler, who's a Deputy Solicitor General of the United States Department of Justice. Excuse me. He argued as amicus. Ed has argued more than 100 cases at the Supreme Court. He's been at DOJ forever. He's been involved in almost all of the major Indian law cases, for the last, I don't know how many decades, a long time. And he, I used to work with him, for him, and he is basically viewed as the litigator who knows the most about these issues in the country. And so I thought one thing that was sort of interesting about the argument was that the justices they gave him a lot of time to talk. I think he was only supposed to have 10 minutes, but he was up there for quite a long time, and I think it just showed their sort of respect for his body of knowledge and not deference in the sense that they're just going to accept his position, but sort of like they were interested in having him help them understand the issues in the case. All right, so I'm going to be showing the results. I think you'll see them, but I'm going to announce them either way. And so we have, people think Mr. McGirt is going to win. 70% people think Mr. McGirt is going to win, and 30% think that Oklahoma is going to win. So that's interesting. I want to respond to one question, and sorry to keep monopolizing the microphone here, but there was a question that I saw pop up that said, why should the justices care about practical consequences when they're just supposed to be interpreting the law? And that is like that is a philosophical kind of question that the justices struggle with. It's certainly Justice Gorsuch's view that they should not, that all they should do is read the text, but others don't have the same view. So it's just different people have different views about the role of judges. So there's no real answer to that. Okay, so people think Mr. McGirt's going to win. I don't know, Bob, you can go first or second if you want to give a prediction on what you think is going to happen.
Well, I'm going to go with Mr. McGirt, and with the majority out there, I think that Justice Gorsuch is going to carry the day here, and that Breyer will go along with it and let the chips fall where they may.
Interesting. Okay, so I'll be the rabble-rouser. I think Oklahoma is going to win probably in a narrow way. I agree that Justice Gorsuch is going to was probably going to vote not disestablished. I think he'll probably have Kagan and Sotomayor and Ginsburg on his side. I don't know about Breyer. He seemed really stuck on trying to find a narrow ground, and so I could see 4 votes for the reservation has been disestablished or never existed, 4 votes for it exists, and then a 5th vote for we don't have to decide that, or a 9th vote, I guess, for we don't have to decide that because the state has criminal jurisdiction anyway, which would end up being a vote for Oklahoma on the ultimate result. So we'll see. We should know by the end of June. Do you have any closing thoughts? Or?
No, I think it's a fascinating case, and it was great to be involved with the SCOTUS blog and you to help present this, and I hope the students learned a lot out of it.
Yeah, so thank you, and we really appreciate your joining us, and we appreciate all the audience members joining us and students. And there's one more day of telephone arguments tomorrow morning, and so you should tune in. They're being simulcast on C-SPAN radio and cspan.org. If you go to cspan.org, the website, you will also see sort of live blogging from some of my colleagues and other SCOTUS blog contributors to sort of help give context for some questions. So who knows if there'll ever be telephone arguments again? Maybe there will be next year too. Who knows how long we're going to be in this situation? But it's a really, normally people are not able to listen to arguments at the Supreme Court as they're happening. So this is a great opportunity. So there's one more day. So we hope you'll tune in and keep tuning into SCOTUS blog. Thanks so much.